si quelqu'un vous fait mal, vous allez chercher le juge. Mais si les juges vous font le mal, que feriez-vous?
Imaginez que vous êtes juge en Turquie, où 30% de vos collègues ont été licenciés et la plupart d'entre eux ont été emprisonnés et condamnés, et que vous savez que si vous prenez une décision qui ne plaît pas au gouvernement, vous serez considéré comme un traître et un terroriste et serez licencié et arrêté. Que feriez-vous? Agir de manière indépendante et impartiale ou agir comme à la suite du gouvernement?
Mesdames, Messieurs, bonsoir. Je vous souhaite une belle soirée de panel. D'abord, je vous remercie pour cette opportunité. Et aussi, j'aimerais dire merci à M. Stadelmont. Après coup d'État, juste après le coup d'État, il était là pour nous soutenir. Il n'y a pas de mots pour décrire la valeur votre existence à cette époque-là. Merci. Et merci au nom de mes collègues, parce que nous étions très coincés et nous étions très seuls dans notre pays, même aujourd'hui. 17 janvier 2018, j'ai été arrêtée, 3e fois, par la décision de Tokat. Tokat est une ville de Turquie, mais pourquoi Tokat? Je n'ai aucun lien avec cette ville, je n'ai aucun lien avec ce procureur. Mais pourquoi? C'est bizarre. C'est comme ça, on ne sait pas. Ce procureur a systématiquement fait cette manière pour les juges femmes. Il utilisait différentes tortures physiques et psychologiques pour nous forcer à dire ce qu'ils veulent. Et il a appliqué diverses tortures, comme je vous ai déjà dit. Pourquoi? Pour gagner la légitimité à ces dossiers. À côté de celle-là, dans la chambre, toujours une caméra qui surveille. Mais une fois, 2 fois, les 2 ou 3 polices qui sont venues et m'amènent d'autre côté sans caméra. Ils m'ont demandé de dire quelque chose, ce qu'ils veulent. Et j'avoue que j'avais très, très peur. J'avais très peur d'avoir torturé par les polices. Parce que leurs attitudes, c'est très, très menaçant contre moi. Et je suis restée ici 10 jours. Et après 10 jours, j'ai détenu par la décision le tribunal de Tokat. Ce qui m'intéresse ici, c'est que c'est très important, ni le tribunal, ni le procureur, il n'y a pas d'autorisation sur mon dossier. Mais malgré toute la violation, après 10 jours, j'ai eu la chance de voir les lumières du soleil. C'était sympa, à côté de celle-là. Donc, j'ai déplacé dans la prison à Tokat. En entrant, elles m'ont fouillé nue, malgré le système X-ray. Mais cette manière était déjà interdite, vous connaissez. Je ne préfère pas prononcer les conditions, je vous laisse lire. Et ensuite, je suis arrivée à ma cellule, qui était 2 étages. Il y avait le procureur, les juges, les enseignants, les polices, les soldats, partout, et 3 enfants. Nous étions 23 personnes dans la cellule qui est la capacité vide. Je suis restée ici 3 mois, plus, jusqu'à mon audience. Pendant mon audience, ils ont accusé par l'article 74 du Code pénal. Ça veut dire quoi? Ça veut dire être membre d'une association terroriste. Il y a la preuve contre moi, être juge. C'est l'accusation principale. Être marié avec mon mari et être ami avec mes amis. C'est tout. Et quand on a parlé de la violation, il y a autre violation. On a vu que ils ont changé l'article. Ils ont changé d'avis tout à coup Et cette fois-ci, on a besoin d'une autorisation du ministère de la Justice.
Merci Carrie, merci tout le monde. Je suis vraiment heureux d'être là. Je m'appelle Fatih Önder. En avril 2015, deux juges, Metin Özçelik et Mustafa Başer, ont rendu des décisions de libération en faveur des policiers qui ont mené les enquêtes sur la corruption. Et en décembre mais ces décisions n'ont pas été appliquées. De plus, ces deux juges, ont été immédiatement licenciés par le Conseil et ont été emprisonnés plus tard, quelques jours après. De plus, en septembre, le juge Süleyman Karaçuk, qui a participé à l'enquête sur la corruption, a aussi été emprisonné le 15 juillet 2016. Ce jour-là, une tentative de coup d'État a eu lieu en Turquie. Et les organes judiciaires indépendants n'ont pas encore clarifié qui l'a organisé et exécuté. Mais au petit matin du 16 juillet, je veux dire seulement plusieurs heures après la tentative de coup d'État, alors que l'identité des soldats qui ont participé au coup d'État n'était pas encore déterminée, le Conseil, sans leur accorder aucun droit de défense, a suspendu 745 juges et procureurs. Sur la base de cette décision de suspension, je répète, uniquement sur la base de cette décision de suspension, parce qu'il n'y avait rien d'autre comme raisonnement dans le dossier d'enquête, le bureau procureur général d'Ankara a émis cette offre vue à l'écran. Comme vous pouvez le voir dans la traduction, cette offre indique clairement que ces 2745 magistrats doivent être immédiatement arrêtés et pire encore, que leur détention doit être garantie. Et à l'exception de ceux qui se cachaient, ils ont tous été détenus. Certains d'entre eux ont été arrêtés alors qu'ils menaient des procès dans des salles d'audience. Vous pouvez imaginer l'impact de ces détentions arbitraires sur les autres juges. Vous vous demandez peut-être quelles étaient les preuves contre ces magistrats, ces juges et procureurs pour l'accusation de terrorisme. Comme vous pouvez le voir à l'écran, voici les principales preuves du terrorisme. 1. Voter pour le candidat indépendant à l'élection du Conseil, publication sur les réseaux sociaux, c'est désabonner de Digital Cable TV entre une période spécifique, adhésion à l'Union de juristes YARSA, adhésion au comité d'annuaire des diplômés, mission à l'étranger, notamment à la Cour européenne des droits de l'homme, aux formations linguistiques à l'étranger, envoyer les enfants dans des écoles privées affiliées au groupe Guleniste, avoir un compte bancaire à Bancasia, télécharger une application de chat sécurisé appelé Philo. Et même obtenir un soutien économique de l'Association européenne de juges. En fait, pour comprendre comment le système judiciaire fonctionne en pratique en Turquie, il suffit de chercher sur Internet pourquoi Osman Kavala et Selahattin Demirtaş n'ont pas été libérés, pourquoi Şebnem Fincancı a été arrêté et condamné, et comment Deniz Yücel et Andrei Brunson ont été libérés juste après les conversations d'Erdogan avec Mme Merkel et M. Trump. Je voudrais terminer ma présentation en vous posant une question. Imaginez que vous êtes juge en Turquie, où 30% de vos collègues ont été licenciés et la plupart d'entre eux ont été emprisonnés et condamnés, et que vous savez que si vous prenez une décision qui ne plaît pas au gouvernement, vous serez considéré comme un traître et un terroriste et sera licencié et arrêté. Que feriez-vous? Agir de manière indépendante et impartiale ou agir comme à la suite du gouvernement? Merci pour votre attention.
Merci, Monsieur Père, pour la présentation. Nous, heureusement, ce soir, on ne connaît pas de liste noire, mais sur notre liste, il y a beaucoup d'orateurs intéressants. Nous accueillons donc Bajak Elmas qui nous rejoint en ligne. Elle va nous donner une impression sur la violation des droits de l'homme à l'égard des juges pendant leur détention.
The democratic backslide of Turkey continued also after 2019 until now. And as we saw in the Osman Kavala and Demirtaş cases, the Turkish courts have been rejecting to implement the decision of European Court of Human Rights regarding the case of Turkish judges. And in November 2021, court issued a ruling on the pretrial detention of 400 applicants and ruled their pre-trial detention have been unlawful, and I think it's now more than 200. On 16 April 2019, the European Court decided that the detention of second chief judge of the Turkish Constitutional Court, Alparslan Aslan, was unlawful. And Turkey's appeal against the judgment was dismissed. And however, Altan has not been released since then. And worse, he was convicted and sentenced to 11 years over the terror charges in 2019. This was despite the European Court's decision. And another member of the Turkish Constitutional Court, Erdal Tercan, who sentenced to 10 years and I think 7 months over the same charges. And trying court did not consider the decision of European Court. And as I want to say that judges all over the world have suffered from human rights violations, but nowhere in the world have thousands of judges at the same time been the subject of that many human rights violations. We have been subjected to all kinds of human rights violations, including that because some of us were not released from prison despite being seriously ill, and torture and imprisonment without a fair trial, poor prison conditions, deprivation from the health care, insult, and social isolation, humiliation in the society, and unemployment, deprivation of our property. Some of our colleagues were forced to march through the streets with their hands in cuffs, and the people were shouting at them, and they were constantly stopped by the use of such words as terrorists. And those of us who were lucky have thrown ourselves here in Europe, and we are making an extraordinary effort to be able to get back a normal life, to integrate ourselves to the countries that we live in. However, it is sad, but the 1,000 former judges and prosecutors who were in Turkey, it is for them, it is unfortunately heartbreaking. For example, solitary confinement is one of the most serious rights violations in detention, and many judges and prosecutors, including women, are still held in solitary confinement. I have had a chance to talk to some colleagues after their release, and some of them have been in solitary confinement even for years. And it is especially so when the person was for example, high court judge or held in a higher position in the judiciary. And the wards are filled with prisoners for above their capacity. It has become an ordinary practice to keep 40, 60 people, members of the judiciary in cell, which are suitable for 8 or 9 persons. And on the other hand, practices against human dignity, such as insult, swearing, threats, and humiliation, are accepted as ordinary acts. Many judges in prison were and still are faced with human rights violations during detention, and these range from benefiting from social rights while in prison, over being forced with sign a petition, accepting member of the organization and expressing remorse for conditional release, not benefiting from conditional release, even the time period passed, and these are the situations. And the situation in prison for some colleagues has become so dire that who speak out about human rights violations in prison can be subjected to disciplinary penalties, such as ban on visits and letters, or depriving for release on probation for this very reason. And their life in prison may be further aggravated. And yes, I want to give some examples about it. The former director of the Justice Academy of Turkey and the candidate of the High Council, Judge Ayşe Neşegül, and her husband have been detained since coup attempt, and she was a candidate for High Council. Following her candidacy, she was targeted by pro-government media, and numerous slander conducted against her. However, she did not give up and continued her candidacy. And after the establishment of the new council, she and the other candidates competing in the elections were relegated and posted to other provinces against their will. And Ayşe Neşe was appointed to Edirne with her husband, and they were abroad actually during the attempt coup, and they knew that they would be arrested, but nevertheless they returned to the country. They were detained after their return, and she was handcuffed for days. She and her husband is still in detention, and sadly they are even in solitary confinement for years. Another example is another woman judge, Yeşim Sayıldı. Her story is almost identical to Judge Ayşe Neşegül, and she and her husband have been subject to similar treatment. And she was also one of the candidates for the elections. However, when the government supported Judiciary platform won the elections, their first election was relegated, they revised to post in different provinces, and therefore she and her husband were relegated to Samsun, another district. And they were both arrested, and after 5 years in solitary confinement, they were released. What can be done? What we see in Turkey is the reflecting of what's going on around the world. And I don't think that in general we are giving a good test in terms of rule of law around the world. There is a war going on within the borders of Europe right now, and the judges in Poland, in Hungary, in Romania are still struggling with the rule of law. If you raise consciousness about and fight for the rule of law around the world, at least we can hope to stop deficiencies in the function of democracy. For example, recently a pleasing decision came from the European Court of Human Rights regarding the Polish judges, and the court provisionally suspended forced transfer of 3 judges of Court of Appeal in Warsaw, and the applicants were involuntarily moved from the criminal division to the social security chamber. And it is an unprecedented decision to protect Polish judges from unlawful proceeding. And now we are, as former Turkish judges, expecting and hoping that the European Court of Human Rights applies the same high standards that they apply to the Polish judges, to the Turkish judges. To us, who have suffered from severe violations of rights in Turkey, Turkey is a country which is a founding member of the Council of Europe, by the way. And I think Turkey has a few years of experience with an independent judiciary, and unfortunately had not enough time that it became a tradition and institution. And finally, perhaps what's gonna save us is a real independent judiciary, but I'm afraid it's gonna be a long struggle. Thank you very much for listening.
In normal country, or imagine that we are all in Switzerland right now, the job interviews take place for the evaluation of competences and qualifications for an applicant. But in Turkey, our colleagues, when they apply to vacant job positions, they have either been disqualified in preliminary investigation of the employer, or they have been demanded to work in an unregistered way without any social security coverage, social security protection. At this stage, one would assume that why they don't work as lawyers, and it is quite impossible because of the objection of the Ministry of Justice. Our colleagues, when they demand to work as lawyers, they are being granted provisionally to work as lawyers, but just for 3 or 2 months. After that time, the Ministry of Justice challenged the decision of Turkish Bar Association before administrative courts on grounds of ongoing investigations and adjudications of terrorism charges. And after that period, the administrative courts revoked the license of our colleagues, and they prevented our colleagues from carrying out the lawyership profession as well. And this is all being done despite the presence of clear articles in the Constitution, and as well despite the decision of Constitutional Court, which emphasizing the presumption of innocence. And you see one petition which was written by the Minister of Justice for the annulment of the license of one of our colleagues. This document is also real. And also, as you see on the images, many of our colleagues try to find solutions to overcome the difficulties of life, because they have under the obligation to feed themselves and to feed their families. That's why they have to work in different parts, in different sectors of the economy, and they have had to make this tough choice for creating something bizarre for them. And also, you may see them selling watermelons, or working as a butcher, or selling olives. I also add one other document, as you see on the screen. This is the experience of one of our colleagues in Turkey as well. When he applied to insure his car with compulsory car insurance, he was rejected on the basis of this document, the explanatory note on his social security certificate. And imagine a country when you apply to insure your car with a compulsory car insurance, and the system popped up a warning that you are under investigation, you are a terrorist, you are enemy of state, and you don't have any right to insure your car with compulsory car insurance. And also, I'd like to add something as well for this part. You may see, nevertheless, despite all these adjudications, you may see, nevertheless, see our judges, our former colleagues, work in the lawyers' offices. But they have always used the backdoor. They don't have any legal capacity, and they don't have any official right to represent their clients, or they don't have any official right to join to the hearings. And they always have to use the backdoor, and they have to disguise their identities all the time. And I'd like to continue with another thing, another problem for our colleagues. This is the passport restrictions and foreign travel bans. As you know, right to freely travel is a human right, and which can be restricted only on relevant grounds, and which are clearly stipulated in relevant laws. There is no other way to impose the travel ban, foreign travel ban, to anyone apart from competent court. And the story about travel restrictions and foreign travel bans started with an amendment brought by the executive decrees. Well, when they brought this restriction to ones under the terrorism charges, this decision was challenged before the Constitutional Court of Turkey, and the Constitutional Court of Turkey unequivocally annulled that provision and clearly stated that there is only courts who have the sole authority, who have the only authority to impose travel bans. And despite the clear decision of the Constitutional Court, and also despite the clear provisions of the Constitution, the Interior Ministry sees itself above the law. And they responded to the court's decision, Constitutional Court decision, by issuing a new decision. And with this decision, they annexed 60,000 people's name, and they simply ordered the police headquarters, the national police systems, not to issue passports to those who are annexed to that list. And this is like an administrative coup d'etat, je pense. And I like to see you to demonstrate the level of protection between theory and practice. I'd like to read you the articles, relevant articles of the Turkish Constitution. Article 13 of the Turkish Constitution, as you see, fundamental rights and freedoms may be restricted only by law and in conformity with the reasons mentioned in the relevant articles of the Constitution without infringing upon their essence. These restrictions shall not be contrary to the letter and spirit of the Constitution and the requirements of the democratic order of the society and the secular republic and the principle of proportionality. And Article 23, paragraph 4 of the Turkish Constitution, a citizen's freedom to leave the country may be restricted only by the decision of a judge based on a criminal investigation or prosecution. And also, I like to continue with another problem, which is the risk of re-imprisonment. The minimum sentence membership to an anti-terrorist organization, which is 6 years and 3 months in Turkey, and which requires 4 years and 8 months minimum serving time in prison. And it is the fact that there are several judges and prosecutors who were released from the prison before serving their full time in closed penitentiary system. But their cases are still pending and their sentences waiting for to be finalized before the Court of Cassation. And according to politicized current climate judiciary of Turkey, their sentences are highly likely to be upheld by the Court of Cassation. And that means that they all have to live under the stress to be re-imprisoned and to serve their remaining time in the closed penitentiary facilities. And they have to live with that. And also, in pertinence with this issue, I like to recall our dear colleague and his dear wife, Ibrahim Gündüz and Nurdan Gündüz. They lost their lives while trying to escape from the persecution in Turkey. They lost their lives in the cold waters of the Aegean Sea because they need to, or they wanted to, restructure their lives from scratch. They want to escape from the open prison of Turkey. But they didn't manage it, they couldn't manage it, and they lost their lives in the hope that building a new life outside of Turkey.
First of all, thank you very much for this invitation, and let me greet all the participants. I'm an Italian judge, and I'm also board member of Justice for Rule of Law Association. And I would like to greet our Secretary General, Yavuz Aydin, who is among the participants. I'm honored to be the only not Turkish speaker in this panel. And why I'm speaking this evening. I was European Union independent expert in Turkey for more than 7 years, almost 8 years, since 2007 until 2015, when the negotiations for the accession of Turkey were de facto suspended. And in this capacity, I performed several missions to Turkey, especially the most important annual peer review mission in view of the annual progress report, the European Union, European Commission about Turkey. but also follow-up technical missions, conferences, and I drafted several official reports. I was independent expert, so I did not commit to the political authority, but often my recommendation and my conclusions were included in the political document about Turkey, in the context of the negotiations. Why am I speaking about negotiations? Because I will come then to the content of my intervention, which is what can Europe and Switzerland, political bodies, policymaker, institution do. I would change it in what should have done, because now the situation has gone very, very far, and it's difficult to imagine to go back to the rule of law in a short time. I'm speaking about this role because we have to remember that between European Union and in the Council of Europe and Turkey, there are legal agreements. I mean, Turkey even signed an association agreement with the European Community at that time in 1963. And then another treaty, which is Custom and Union Agreement in 1995. And in 1999, which is now almost 23 years, it's 24 years, it got the status of candidate country for the accession of European Union. After the status, the negotiation formally started in October 2005. After 2 years, I started to work in Turkey. So negotiations are formalized process, according to which one chapter, there are many chapters, has to be opened and closed unanimously by decision of the member states when the acquis communautaire is reached by the country. And during those missions, so there has been significant progress along the year, and Fatih has reconstructed very well the situation. Especially important were the constitutional reforms of 2010 that reinforced significantly the judiciary and the constitutional court, especially setting up this judicial council elected by majority by the peers. And during that time, we focused on many aspects of this European standard. Just to make an example, I remember that in 2013, among other many things, we focused on a transfer of some judges from one duty to another one without a clear justification, without a disciplinary proceeding. So we were considering few judges who were dealing with sensitive cases in Turkey at that time. So there was a high attention in my report and also in the progress report about the case, I repeat, of few judges dealing with some sensitive cases. Then after 2013, because myself as Fatih, I place the change of the atmosphere, the change of the situation in Turkey in 2013, when two important events happened. Fatih has reminded the corruption probe in December 2013, but I would say that, at least for the civil society, is even more important the Gezi protest and the violent suppression of the Gezi protest in May 2013. I mean, in the following years, there has been a mass transfer of judges and prosecutors without justification. We're speaking about hundreds, if not thousands, of judges that were moved from their duties to other duties. It was basically a punishment for some of them. For others, it was a way to bring them away from the cases. So it was already clear at that time that there was a big disruption of the rule of law. Then many events happened that, if you are interested, are reported in a comprehensive report that I have the honor to write for a tribunal that was set up by the civil society, European Civil Society, and had its session in Swiss, in Geneva, in September 2021, in front of an international jury against Turkey. And I drafted the report. It was reported about judicial independence and access to justice. This report has been endorsed by the two most important associations of judges in Europe, the European Association of Judges and MEDEL, and Felipe Marques, the former president of MEDEL, was connected until some minutes ago here. In this report, you can find a comprehensive analysis about what happened along the years. And as I said, changes happened already in 2014 and 2015. But after the coup d'etat, we have seen an incredible situation. I would say never seen before in other countries, because it's not only a matter of this terrible situation of judges who have been arrested and dismissed, but we are speaking about more than 215,000 people who have been accused to be terrorists, according to this highly criticized anti-terror law, including more than 300 journalists, including free minds, including writers, including members of the parliament, especially of the HDP, the pro-Kurdish party, or many measures in towns in southeast of Turkey. And we should never forget the fact that this anti-terror law that has been used in this case against let's say the civil society, the free minds, the political opponents, had been used before that against the Kurds for a long time, without, in many cases, a proper justification. And so it is an unbelievable situation regarding the ruin of rule of law in a country which is, as you said, not only bound by treaties in respect to the European Union, but also is a founding member of the Council of Europe that Turkey accessed the Council of Europe in 1950, and is also one of the original members of signing the European Convention of Protection of Human Rights, so it's subject to the decision of the court. So in this situation, what should be expected from the political authorities, the policymakers? And first of all, since formal treaties have been severely breached by Turkey, there should have been a legal reaction. So this is a legal issue. So some of us, I'm a judge. This is normally when a treaty is breached, the consequence should be that the treaty is dissolved. I mean, the cooperation is dissolved. At least the negotiation should have been terminated. This is a normal consequence that we should have expected. These negotiations have been suspended de facto, and then there was also a resolution of the parliament in 2019, but they are still there. They are still pending, and still there is a cooperation, which is also political cooperation. If we consider that in March 2016, it was signed a treaty, an agreement is not a treaty. It's an agreement which is a legal nature, which is not totally clear, between the European Union and the member states and Turkey about the externalization of the European border for those seeking asylum and coming from Turkey. It is a billionaire agreement, which is still in place. That means that Turkey has become a sort of ally of Europe regarding the policies about migrants. But at the same time, we should consider that if you look at the last report of the European Union Asylum Agency for Asylum, we will see that in 2022, Turks were the third largest group seeking asylum in Europe, the third largest group after Afghan and Syrians. Only in November 2022, there has been more than 8,300 applications for asylum from Turkish people. So there is something which is really not understandable, that Turkey is a political ally for what regards the externalization of the border. At the same time, we have such high number of Turkish people seeking for asylum. The second, I mean, so the European Union has failed to implement the legal obligation in respect to the treaty signed with Turkey. Second, the institution again, the Court of Human Rights. The Court of Human Rights has been highly disappointing. We have to admit this, because people have been arrested and dismissed, and they immediately filed the application to the Court of Human Rights that was reached by thousands and thousands, if not 100,000 of applications by Turkish people. But the first decision came very late, considering that these people were in jail. Some, as we heard, have been even tortured, because the case of Alparslan Altan, that was the deputy president of the Constitutional Court, that was the first institution to be hit after the coup d'etat, because it was an institution that defended for some years the fundamental rights of the citizens. It came in April 2019. It is almost 3 years from the fact. It is late. And it is not only late, but it's also disappointing to other respects. For example, the decision adopted in November 21 regarding the case of Turan and others, because of lack of resources. This is a very strange decision to my mind. The Court of Human Rights decided to consider only one complaint, and not the most important one among the complaints brought by the applicants. So for the court, it was sufficient the conviction for one complaint, but the other were disregarded because of lacking of resources. So what the institution should do, the institution should, as someone say, apply the same standards, also the Court of Human Rights, to the Turkish claimant and the other claimants. The standards has been different for Poland, as someone already said before. The third point is about the civil society initiatives. Okay, if there is not a proper political action, even with a political intervention, I mean, the situation is not easy in itself. There's apparently the majority has been strong enough to resist along the years in Turkey. But a political action would be needed in this case. The civil society is important to raise the attention, not to keep the focus on Turkey, like the conference of tonight, or for example, the initiative, the Turkey Tribunal that I mentioned before, that you can find everything, reports and video, and what else in the internet, and the promoter of the initiative, lawyer Professor Van der Lanot, was the one displayed in the videos that were projected by you during the break in the hearing in front of the Court of Human Rights. And also for political pressure, the civil society can bring pressure on the politicians in order to adopt expected decision. Then there is also room, of course, for the associations. I'm myself part of this association, that Justice for Rule of Law, that was created after by some basically judges who are refugee abroad. It is important, first of all, the association to support the Turkish refugees, the judges, but also other Turkish refugees, and again to raise the attention of the public opinion. Let me here mention the platform for an independent judiciary that was created by the four main association of judges in Europe: the Association of European Administrative Judges, the European Association of Judges, Judges for Judges, and MEDEL in 2016 after the coup d'etat. And its intervention has been very effective in front of the institution and also in front of the public opinion. They have produced many documents and that are very important for the support of those who suffer in Turkey and abroad. Thank you for your attention.
Après la chute suivie de l'affaire, le politologue américain Francis Fukuyama a déclaré la fin de l'histoire en proclamant la victoire la démocratie libérale sur les systèmes autoritaires. Or, on constate que le plus grand pays du monde, la Chine, est loin d'être démocratique et des tendances autoritaires gagnent du terrain aussi au sein de l'Union européenne, comme vous l'avez mentionné, comme cela a été mentionné dans une présentation. Un critère des pays autoritaires, c'est de contrôler et de manipuler la justice. Comment est-ce que nous pourrions renforcer la résilience, la démocratie, qui devrait jouer un rôle crucial pour renforcer la résilience, la démocratie?
I'm a judge. I would prefer to answer legal technical question, even though having being an independent expert, I've dealt with, let's say, general constitutional systems, some way also to considering some political changes. I've been expert in many countries, not only in Turkey, but also in the Western Balkans. I mean, my personal opinion, but this is really personal, is that in many countries in the world, many people don't trust democracy anymore as a model of government. In the sense that after many years of government by democratic societies, many people feel to be excluded from the political power, the economical power, and that their ambitions, their hopes have not been met. So this is my personal opinion about why we are facing a crisis of democracy in many countries, and even, this is the point, even in the European Union. This was not considered at the time of the establishment of European Union, to the point that when the European Union was created, the principle grounding the most important decision has been, it is still the unanimity, because it was not possible to imagine that some members of the group would have diverted from the basic principle of the system, for example, rule of law, or the protection, I mean, the systematic violation of fundamental rights. And this is an enormous political problem for the European Union, because until this rule will not change, everything is stopped, in the sense that it was not possible to adopt the sanctions provided by Article 7 of the Treaty of European Union regarding the breach of the treaty or the EU law by some member states. So how to protect democracy? How to protect democracy? So this is now is a matter for everyone to defend it. I mean, at every level, because democracy is at risk even in European Union. So until we believe, and I believe, I trust this model, is everyone at every level that do his on her best to protect the principle. I hope I've given my contribution. This is a very difficult question. Thank you very much.